Oh, yes, oh, yes, oh, yes. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Welcome to the May docket of the Court of Criminal Appeals, Western Division, sitting in Jackson. On the docket today is our court's presiding, on the panel today with me is our court's presiding judge, John Everett Williams from Huntington. We are also joined by Judge Jill Ayers, who is from Clarksville, Tennessee. Judge Ayers is new to our court. She had previously served with distinction as a trial court judge in Montgomery and Robertson County, was recently appointed to the Court of Criminal Appeals, and we're very glad to have you with us today, Judge Ayers. We will follow our usual rules as to time limits, affording each side 20 minutes. However, if we get into the argument and see that more time is needed by the appellant or by the appellee, you can just say so to us and we will accommodate you. My understanding is that the appellant wants to reserve some time for rebuttal. Is that correct?
Yes, Your Honor. 5 minutes, please. That'll
be fine. And we will just make whatever adjustments that we need to if they're needed. Let's see. Judge Williams is not presiding today because we've had some power outages and other technical difficulties, and his audio is not working up to speed. So that's why I'm filling in. If you would call the first case, please.
Corinio Pruitt versus State of Tennessee.
All right, on behalf of the appellant.
Good morning, Your Honor. Kelly Gleason on behalf of Mr. Pruitt. It's my honor to represent him before this court today. May it please the court, Mr. Ball. This case is before the court on a markedly different record from the direct appeal. And in that direct appeal, the Supreme Court ended up splitting 3-2 decision on the issue of proportionality regarding Mr. Pruitt's death sentence. And I'm going to get into that a little bit more in a minute. But first, I wanted to let you know that we believe that the post-conviction evidence undermines confidence in either the guilt verdict or the sentencing verdict in this case. We have 15 claims of error in our opening brief. Today, I hope to focus on 2, possibly 3 issues, which alone or combined require that the conviction and the death sentence be set aside. First, I will address the issue of ineffective assistance of counsel in the investigation and presentation of mitigation evidence, and specifically in regard to Mr. Pruitt's cognitive impairments and his social history mitigation. That issue is argument 5 in our opening brief. Second, I will address trial counsel's deficient and prejudicial failure to investigate and present evidence of adaptive deficits in order to establish Mr. Pruitt's intellectual disability. And I would note that the record was so thin before this court on the direct appeal that the court commented on the dearth of any evidence of adaptive deficits, which frustrated the court since that is one of the 3 prongs of intellectual disability. Third, if sufficient times remains, and that would be issue argument 6 in the opening brief, the intellectual disability claim. And then lastly, if I have time, I'll address the Batson ineffective assistance of trial and appellate counsel claims, which are interesting claims that the court doesn't see very often. That is argument 3 in our opening brief. So just to set up the context for the ineffective assistance of counsel on the mitigation. I think first we need to talk a little bit about the crime itself and then the proportionality questions that caused our court to so severely split on whether death was a proportionate sentence in Mr. Pruitt's case. This case was charged, the Shelby County District Attorney charged 2 counts of first-degree murder. One was felony murder, the second was premeditated murder. The jury returned a second-degree murder verdict on the premeditated count, so rejecting the state's idea that this crime was in any way premeditated. The jury found him guilty on the felony murder count and sentenced him to death after a very sparse mitigation presentation. The presentation was so sparse that the Attorney General before this court on direct appeal argued that the mitigation evidence was slender, and then made the same argument in the Tennessee Supreme Court. So in the Supreme Court, the court heard oral argument, I believe in June, and then in December issued an order asking for supplemental briefing on several proportionality issues. One was the way the court conducts the proportionality analysis, and therefore the way this court would conduct proportionality analysis. And then there was another issue too about whether for a felony murder in which Mr. Pruitt showed up unarmed and without the intent to kill anyone, whether death was disproportionate. The court has answered that question for us. The answer was by a 3-2 decision that death was a proportionate sentence. But I do think this frames the issue of ineffective assistance of counsel regarding the mitigation, because it certainly does suggest that even the smallest amount of mitigation would tip the scale. So I'll get into that in a minute, but just a brief few points about the dissenter's opinion on the proportionality. Number one, the dissenters noted that the death penalty is the state's most drastic punishment, and it does not fit Mr. Pruitt's crime. And the dissenters believe that because Mr. Pruitt was unarmed, the encounter took 15 seconds. The victim was a quite lovely elderly man who died in the hospital over a day later from his injuries. Had it been another victim, this would not be a murder case. After learning that he in fact had killed Mr. Guidros, Mr. Pruitt turned himself in. And in the state's brief, the state portrays that as Mr. Pruitt going to his co-defendant's grandmother's house and then being apprehended when officers arrive in in unmarked cars. Actually, what happened from the trial record is Mr. Pruitt was on the corner of Bellevue and South Parkway, and he called the police and said, "Come get me." And then the police came and got him. He went to the homicide office. He gave a statement. He said that he grabbed Mr. Guidros, he pushed him down, and he took his keys and he took his car. And he said he was very sorry for what he did. So getting into that from that context, into this issue of ineffective assistance of counsel regarding the mitigation in this context, the state's reference on the direct appeal to the proof available at trial and presented at trial regarding that it was slender was made at the state's brief filed June 14th, 2010 on page 32. In the Supreme Court, the state made the same assertion again in a brief filed January 6, 2012 at page 34. So once again, I do believe this suggests that we need to prove deficiency and we need to prove prejudice, and I'm going to get into the proof on both of those counts now. But it does suggest, given the offense itself, that mitigation was extremely important to contextualize the felony murder for which Mr. Pruitt was convicted. And at trial, the state presented Corinio's mother, Vivian, his sister, Kiana, Dr. Rutledge, who was an expert who examined Mr. Pruitt when he was 16 years old and found an IQ of 66. And then briefly called Ralph Nally, their fact investigator with the Shelby County Capital Team, the Public Defender's Office Capital Team, to say that he tried to find Corinio's father and he was not able to find him. So the deficient performance in this case is not only what we see from the actual proof presented at the trial, but what the Shelby County Capital Team actually did in this case. They interviewed only 7 lay witnesses regarding Mr. Pruitt's life circumstances. They failed to obtain neuropsychological testing, which would have been consistent with prevailing professional norms to examine given the red flags in the case. And it would have revealed a severe cognitive disorder, which is in fact the same cognitive disorder that Jerry Ray Davidson has, that was part of the mitigation proof, which convinced that court that Mr. Davidson was entitled to a new sentencing trial. We believe, and our opening brief states, that the court appeared to have made 2 deficiency findings, and that was regarding Mr. Pruitt's in utero exposure to drugs and alcohol, and to his excessive marijuana use in early adolescence and the impact that it had on his brain's development at such an early age and in such a large amount. The state disagrees with that. The state believes that the lower court was simply conjecture at that point of the analysis, and doesn't agree that there were any deficiency findings. Regardless of that dispute, this court decides that issue de novo. It's a classic Strickland issue under Davidson. It's clear it's de novo with no presumption of correctness regarding the court's decision below. So we believe that the deficiency itself is very clear in light of the Detrick Cole versus state opinion authored by, I believe, Judge Thomas, granting sentencing phase relief due to ineffective assistance of counsel in a case where the Shelby County Public Defender Capital Team, similar as to this case, was constituted of a fact investigator, a mitigation investigator, and 2 lawyers. They met with, by my count from the opinion, 12 lay witnesses. And presented Mr. Cole, his mother, and his father at the sentencing trial. Certainly, this court should also look to the United States Supreme Court jurisprudence, particularly Williams versus Taylor, Wiggins, the line of cases after Wiggins, Rompilla, Sears versus Upton, Porter versus McCollum, all of which are discussed in our Supreme Court's opinion in Jerry Ray Davidson's case. But I would specifically highlight a case that was not in the opening brief that I hope to present in the reply brief, which this court rejected our reply brief lodged on Monday and ordered that we file a revised brief 1/4 the size of the brief that we lodged on Monday. So we are attempting to cut that now. But one of the things I may need to cut is the discussion of Anders versus Texas and the extreme similarities between that case and this case, among which the main difference being that Mr. Anders shot and killed 2 people in an attempted carjacking at a store parking lot. So we believe the proof is fairly clear. Well, it is clear that counsel did not meet the prevailing professional norms. Under Davidson and under the United States Supreme Court case law, in capital cases, there is a duty to do a, quote, thorough investigation. That thorough investigation that is expected of all attorneys in any kind of case is most important in a capital case when it comes to mitigation and the sentencing phase proof. And that simply was not done in this case by talking to a handful of witnesses, presenting very little evidence, and hiring an expert who saw the client for an hour or less when he was 16, and then arming her with no additional information to speak anymore to his mental state, not having her examine him, not having her review records, essentially doing nothing beyond what she had done in the 1-hour evaluation in 1996. So the counsel, sometimes what we find in these cases, and there's some reference to this in the Davidson opinion about it's regrettable that the public defenders had a heavy caseload. Memphis Public Defender Office has had at times a very heavy caseload, but in this case, and sometimes there's concern about sufficient time. In this case, counsel were appointed on August 22nd, 2005, met with their client shortly thereafter, obtained some basic information, conducted a small number of phone interviews, and I believe a few in-person interviews shortly after that. And then only interviewed 1 person in the entire year of 2006, 1 person in the entire year of 2007. Both of those interviews in 2006 and 2007 were with Alma Rocket, who is Mr. Pruitt's aunt and who was a guilt phase witness for the state. It was an opportunity, given that they had spoken with Alma Rocket, to front load some mitigation that was not taken. There was no mitigation developed through her testimony, despite what they knew from in speaking with her. and they didn't present her in the sentencing phase. So then in 2008, right before the trial, which began February 25th of 2008, they talked to a few people in small family member meetings with the witnesses together over the weekend, the Saturday, Sunday, maybe just the Saturday, but definitely the Saturday before the trial began on Monday. And there they interviewed the client's mother and sister, and for the first time met his brother. And as we know from the Cole opinion, it is not a good idea to have family meetings and attempt to uncover mitigation that you in the case and get the truth of the matter when you are potentially speaking to the child of a mother who had been the source of a lot of the mitigation and had not treated the children well, which the abuse of Dr. Cole's mother and father were both at issue in Cole, and the trial team didn't get to it because they were conducting the meetings together and conducting a deficient investigation despite meeting 12 people. Counsel never obtained neuropsychological testing, and they did not obtain psychiatric assistance. Moving to prejudice. So our Strickland and Davidson framed the prejudice inquiry basically in two ways. The first is whether the post-conviction evidence undermines confidence in the sentencing outcome. But classically, what we know the prejudice analysis to be, and is set out in Davidson and Wiggins, is it's our duty to establish by preponderance of the evidence that the new evidence would likely have caused even one juror to impose life or life without parole instead of death. And in this case, we met the burden by presenting a very large amount of mitigation during the post-conviction proceedings. So what was new in post-conviction that the court does not see in the trial record of this case? Well, first, Vivian Pruitt, Corinio's mother, testified at trial that she, for a period of years, suffered an addiction to drugs and to alcohol. There was also testimony that from Kiana Pruitt, Corinio's sister, that Topeka Pruitt, his other sister, also had an addiction issue. That was all the
Lisa,
yes.
You're getting up to your rebuttal time. If you would like, we can afford you another 5 minutes to talk about, to follow up on your prejudice argument, continue that, and then still allow you the 5 minutes rebuttal.
I appreciate that. Thank you, Your Honor. So I'll try to move quickly through like a bullet list of what's new. So we heard about the jurors heard about the drug addiction. As a matter of fact, Vivian Pruitt, while pregnant with Corinio, was ingesting beer, malt, liquor, whiskey, crack cocaine, pills, marijuana, and she was injecting teas and blues, which contains an opioid. Corinio was born 5 days after his father threatened to beat him out of the womb, resulting in his mother shooting his father several times. This was easily available by pulling Vivian's criminal records, and trial counsel never found that out. He was born in the same hospital where his father was recovering from those wounds. They were on different floors. His father does remember that and which floors they were on. His father doesn't remember whether he met his infant son. His birth records reflect that Vivian did not receive any prenatal care or education. There was horrific domestic violence in his home, which was never presented. There were fights with fists, guns, and knives, and that's the description of the state's expert of his childhood home. As a child, Corinio saw his mother, quote, getting beat like a boxing bag. As a child, he and his whole neighborhood saw Vivian and her boyfriend going at it like, quote, prize fighters. When Corinio was 6 years old, Vivian was hospitalized with a skull fracture. When he was 9 years old, she was stabbed, and he called 911 to get his mother help. His home was a crack house, and his mother's alcohol and drug addictions severely impacted his daily life as a child. There was no evidence of that presented at trial. His mother used drugs with her children, exchanged sexual favors for crack cocaine, and was believed to have pimped out her schizophrenic own mother for additional income. And that was Alma, her sister, that believes that occurred, because when she took over care of her her mother, she had a venereal disease. His grandmother, older brother Rico, and Vivian's boyfriend Buck all sold drugs, mostly crack, out of the apartment. Vivian, Buck, Topeka, and Rico all smoked weed and crack at the home where Corinio was growing up. The house was open 24/7 for people to come and go and drink and use drugs. When Corinio was 4, his mother was arrested at their home after her mother, the grandmother, called police. She was arrested for public drunkenness repeatedly. When he was 8, she was arrested for drinking all day, becoming a nuisance, and then her own mother again called the police to come to their home. She was physically trying to fight the crowd that had gathered at the home due to his mother's behavior. After that incident in 1988, this was when Corinio was 8 years old, there were 5 more arrests for drunkenness. When he was 9, she was arrested for DUI and found urinating in the street. On May 11th, 1991, the day before Corinio turned 11, police were called to the home because Vivian was cursing and screaming, and she was so intoxicated, she sounded like she was speaking a foreign language, as the Memphis police noted. A year later, 2 days before his 12th birthday, Vivian was arrested after she was drunk, wielding a large kitchen knife, which was taken away by one of the older sons, and she cursed her way to the police station. Cindy Hewitt, who is Corinio's neighbor and first girlfriend, remembers that she was at a birthday party with Corinio when he started crying, and she asked why, and he said it wasn't right, and he asked everybody to leave. And she doesn't know what birthday that was, but if it were his 12th birthday, I think we could understand that. He was beaten by his mother, grabbed by the throat, thrown against the wall. He was emotionally and physically neglected and lived in an apartment infested with rodents and roaches. There were holes in the wall that went unfixed. Those holes were there because when Corinio was 8 years old and playing curveball with his friends, Marco the Beast came to his home with an assault rifle and shot a bunch of holes into the home while his family was there. Corinio hit the ground when the gunshots were going off, but he ran to the home to try to find out whether his family was still alive or not. Corinio had to resort to begging for food as a child because his mother sold food stamps for the drugs. When he was 4, he was found wandering around outside in his underpants. He was in a sexually abusive environment because of all the prostitution going on around him. He was sexually abused as a young child, which was never disclosed at trial or discovered. The family's extreme poverty and addiction meant they could not pay the monthly rent, which was $35. And Dr. Abel diagnosed him with severe cognitive impairments, a neurocognitive disorder, and intellectual disability. 3 experts, Dr. Dudley, Dr. Abel, Dr. Everington, testified he is intellectually disabled, that he has significant adaptive deficits, particularly in the cognitive domain. Under the intellectual disability standards, we would only need to demonstrate that he was impaired in one of the 3 domains. He's significantly impaired, as is measured by scientific testing, the neuropsych testing. That was definitively established by those tests. Like in
Okay, thank you. We'll give you an opportunity to address what of that you need to in response to General Ball's argument during your rebuttal. General Ball.
May it please the court, Ben Ball on behalf of the state. Here, trial counsel was not deficient in presenting mitigating evidence. At the post-conviction hearing, petitioners certainly presented additional evidence, a large amount of evidence, but the nature of this evidence was not significantly different. The evidence presented in mitigation and then presented at post-conviction paint substantially the same picture. The evidence at post-conviction hearing simply adds granular detail to that picture through additional anecdotes. But the same themes were present. In mitigation, the jury heard evidence about the petitioner's difficult childhood. The evidence established that the petitioner was neglected. His own mother testified that she was gone for periods. So did his sister. The jury heard significant evidence that about a family history of mental illness, that of the petitioner's grandmother's children, 4 of them were institutionalized. The petitioner's mother testified about her use of drugs and alcohol. It was clear from the evidence presented that this was a home where drugs and alcohol were a major problem. And the petitioner's difficult childhood was brought out through evidence. There's evidence that at a young age, he witnessed the death of 4 of his close friends, and it was a traumatic event. There was no question to the jury that there was evidence of the same themes presented at the post-conviction hearing. It simply added detail, and it was cumulative. And certainly with additional time, you can always uncover more evidence. But the same type of evidence was presented in mitigation and presented to the jury. And thus, counsel was not deficient. And significantly, the petitioner also failed to demonstrate prejudice here. Failed to show that presenting this additional evidence, that while it was additional, it presented sort of no new theme, that it would have yielded a different result. And the post-conviction court properly determined that the aggravating circumstances significantly outweighed that mitigating evidence, and that the jury
did the jury in the mitigation hearing hear comparable expert testimony to that which was presented at the post-conviction hearing?
The jury at the penalty phase heard evidence, expert testimony that the defendant suffered from mental illness. It certainly didn't go into clearly there was a greater depth at the post-conviction hearing, but they certainly heard evidence that about his mental deficits.
Okay, all right, thank you.
Again, it was the same as with the other evidence. It was the same picture, and while there was more evidence presented at the post-conviction hearing, it provided only sort of additional detail, not a whole new area of mitigation. And the post-conviction court properly found that the jury placed a particular weight on 2 aggravating circumstances in this case, the petitioner's prior convictions involving violence and the victim's advanced age, and that outweighed any mitigating evidence in the prejudice analysis. If there are no further questions, I guess the state would rely on its brief for the remaining issues.
All right, sir. Thank you, General. Ms. Gleason?
I think you're muted,
still
Ms. Gleason.
muted.
I just noticed that, sorry.
There you
Thank
go.
you, Your Honor. Thank you, Your Honor. I'd like to pick up on your question, Judge Thomas. The mental health evidence presented at post-conviction was significantly different than that at trial. As I mentioned earlier, at trial, the sole mental health expert who was presented was Dr. Rebecca Rutledge, who had conducted a 1 hour or less evaluation of Mr. Pruitt, which really composed mostly of a brief clinical interview and a Slauson test, which resulted in the 66 IQ. In post-conviction, there was testimony from a psychiatrist, Dr. Dudley, that Mr. Pruitt suffers symptoms as a result of his childhood trauma. And I would specifically point to, like in Dedrick Cole's case, the jury was not informed that the petitioner's ability to make reasonable decisions was damaged as a result of his childhood. So Dr. Everington wasn't given any new information. So all she could speak to was what she had done for less than an hour of someone she barely remembered. That was 1996, so it was about 12 years before the trial. She did testify that Mr. Pruitt had been to MTMHI, that he had been diagnosed with schizophrenia, that there was some evidence of schizophrenia. Primarily, frankly, they were treating him both at MTMHI and the jail for schizophrenia. But that barely got mentioned at trial. And instead, as the state noted on the direct appeal, there was also evidence that he appeared to maybe not be schizophrenic and was malingering potentially the schizophrenia. So there was a serious question about whether he actually did suffer the only mental illness that was pointed to. And then there was intellectual disability. There was no evidence of significant cognitive deficits, which appear in the neuropsychological testing that Dr. Abel did. And I think here the state somewhat conflates intelligence and cognitive impairment, which are two different things. Detrick Cole had an IQ of 78 when he was 66. He had an IQ of 90 at the time of post-conviction. Jerry Davidson had an IQ of 84, yet he had the mental age of a 9-year-old and significant cognitive impairments that led our Supreme Court to say, this is information a jury ought to hear and give credence to. And because of that, and because it is such a significant issue, despite the fact that Mr. Davidson was convicted of, number one, he had a history of what was called malignant misogyny and multiple convictions for sexual violence. And his victim, Jenny Jackson, was found without her body was found without her head in the woods, partially buried. So this case, if we go back to, this is a felony murder, jury rejected premeditation, then it was really important for the jury to hear the evidence that he was suffering from symptoms from his childhood trauma and subsequent adult trauma when he was robbed at gunpoint and lived, in very violent neighborhood and very traumatic circumstances. It was important to hear that he also had serious depression. It was important to hear he had a neurocognitive disorder, an Axis 1 disorder, diagnosed by Dr. Abel, which is the cognitive disorder that Mr. Davidson suffered as well in that case. So it was a completely different picture through the presentation of Dr. Littman, Dr. Abel, and Dr. Dudley than a psychologist, not a psychiatrist, who didn't do any neuropsychological testing, who had seen this man 12 hours before and billed 7.4 hours for her work at trial. That is not the mental health investigation expected by prevailing professional norms in Tennessee. It wasn't at the Davidson 1997 trial. It certainly wasn't at Mr. Pruitt's 2008 trial. And I'm sure I'm almost out of time. I appreciate the court for the time. Once again, we would request that this court vacate Mr. Pruitt's conviction and also convictions and also his death sentence.
Thank you very much. Thank you for your arguments. Madam Clerk, if you will recess us, we'd appreciate it.
This court is in recess until 11:30 a.m.
Thank you.